Here.
Sure.
Go ahead. We are
Good
live.
morning, everyone. And thank you for being with us this morning. My name is Bahman Rudgarni. I'm a paralegal, and today I'm joined by my dear colleague, Ali Reza Hissami. Ali, say hi to everyone, please.
Yeah, good morning, everybody. My name is Arza Sami. I am a paralegal since 2015. I mean, I am licensed since 2015, but before that, I was doing some legal practice, and I mainly deal with the civil litigation, including landlord-tenant board. And the purpose of this meeting, I think, will be some knowledge. For sure, there is no legal advice from us to anybody. We just share our knowledge with the real estate agents who are the side of this story, because first start from real estate transaction, then come to the landlord and tenant board. That's why the main thing is that what real estate agent, what they should do to don't have problems with the clients later, because clients see every problems for the agency. Agent told us this, agent told us that. Thank
Okay,
you.
thank you very much. That was an important point to make. That this is not legal advice. We're just sharing some stuff with you, and let me start with a few issues. And the first things I'm going to cover, and I'll ask Ali for some insight because I admit that he has more experience with his cases at landlord tenant board (LTB). So I'll start with the beginning of this tenancy. That's where you are finding a property for your tenant client, or you're finding a tenant for your landlord client. So we're talking about due diligence and fiduciary duty. Due diligence and fiduciary duty. I'm not here to talk about your due diligence because that is part of what you studied and part of what you got before you got your license. And I'm sure you guys receive trainings, ongoing trainings about that side. But I'm going to bring up some issues that will help when it comes to lease agreements and stuff like that. So, what is your job? Is this only to find a tenant, any tenant, or the right tenant? So, as a real estate agent, you're supposed to do some screening to find the right tenant for your client if you're representing or working for a landlord. So, Ali, could you give us some insight how a real estate agent can use his due diligence, his experience, to find the right tenant, not a troublemaker, not the one who has ripped off previous landlords and now is looking for a new victim. Some of the techniques that we can use as agents to screen and find out if this is to qualify the first step, to qualify the tenant. Ali?
Uh, One of the things which was my own experience, which I figured out, and the landlord actually was a real estate agent himself, but he didn't catch that part, is that when the tenants, now especially during the COVID, maybe you don't see in-person tenants to get their ID. When they give a driver's license to you, first of all, you can go free check the driver license status in Ontario. You just put the license number and the Ontario government say whether it's valid or invalid license. After that, if you see on the side of your driver's license, there's a line, a small line going up, and that line is actually the name of person on the license. If you make it bigger, you can see the actual name of person. What the people do, they come and changed the name on the whatever license they had, but they put, for example, one of the which was all over the news exactly last year. This time it was RF Adnan Sayed, who he changed his name to Sayed RF when and finally we got eviction in landlord tenant board by difficultly before the member by emergency hearing, this kind of things. If they give a letter of reference, for example, I work in this clinic, for example, a salary of this amount. You maybe have to go and check the website of that clinic, see who is the contact people on that clinic. And the person who signed this paper, is it a fake paper or this is a correct paper? They give Equifax information. Try to, I don't know how you can verify Equifax, but maybe you say, okay, you have to obtain it in front of us by your own computer, because they come and change a number of Equifax, which they have another number on top. Or they say, okay, we live in the another property, we did this year, this is a letter of the previous landlord they gave us. You check with the landlord. If it is necessary, go on that property and ask the landlord, is this person your tenant? Actually, I know maybe that landlord want to get rid of this tenant and give you some reference, but when you go face to face, maybe that landlord be some, say no, maybe, yeah, this is my tenant. For my own tenant, I need the the my space. I give a letter to the real tenants that they are good tenants. I need my space. That's why I recommend this tenant. They pay on time.
Ali,
Actually, real estate agent call me.
could you give us the experience you're having with the tenant who turned out to be in escort service and
Yeah,
is
I
not
have a
in the
hearing next Thursday. The tenant, actually this tenant sent a text message to the landlord, and landlord put the ad on KGG. Of course, yours won't be on KGG, but maybe you find the tenant on KGG. I don't know. That's how you work. Then when we Googled that number, we saw bunch of pictures and things coming up as escort service, and still landlord every day different people coming to the house, which we ask for emergency hearing, which will be hearing next Thursday. But this tenancy also starts in 6th of May. I mean, when there is serious, when you ask for emergency hearing, sometimes they allow it and they put it like this case within 2 months. When they enter to the tenancy, they give it. But there is no guarantee when we can terminate this tenancy, because maybe some board member come and say, no, what's wrong with escort services? We don't know. That's the problem. But if the tenant, the landlord himself did that due diligence, then or search the number, at least Google the telephone number. You will find several things when you Google a telephone number. Now you can't Google my telephone number. All my, things coming from, because my telephone number is in my website, you can see everything. That's very important to choose the tenant, because when they enter to the tenancy, when they take a key, I don't say when they sign agreement. That's two different things. When you give a key, then you cannot take that key back. I mean, it will be so much problems to get rid of this tenant if it is even one day tenancy.
again, that's a good point. There's a definition for tenancy. That means if you want to call the police, if you want to change the keys and stuff like that, then you have to have the proper definition of tenancy. When exactly this family or this individual becomes your tenant according to the laws? Could
Yeah,
you tell
actually,
us?
I had several years. It was, I think, 4 years ago, which the tenant entered to the tenancy, and this is one of the experience which I have uh, the tenant entered to the tenancy, for example, from 1st of July, and they sign an agreement. He paid also first and last by the draft to the real estate agency who was Remax on that time, I remember. Then the tenant has a car painting company, and car painting company say, okay, if the landlord allow me, I can change the flooring. The landlord was happy. Okay, he want to put a new laminate. He start to put a laminate, nice one. I was representing tenant actually, and this is one of those cases I lost, and I was so disappointed. But that's how I learned what could happen when the tenancy start. Let's say on the 30th of month, before the first day started, landlord come and change the lock. He said, I don't want you as my tenant. I don't like this, flooring. Tenant already gave a notice to previous landlord. He has to move out because he was packed. I brought an emergency motion, which they do the hearing within 48 hours. I mean, we had a hearing on the 2nd of the month because of the lockout. And it was before the vice chair. Actually, the board, landlord tenant board, they have a chair and vice chair. Vice chair is the boss of everybody over there. The finding after 4 hours hearing, 6 witnesses, the finding of the vice chair was that because the tenant, which they called tenant, but it was not a tenant, it was a normal person because there was no tenancy, did not give an insurance from 1st of month and did not move in on 1st of month. He was just doing some carpenting. If he was moved, if he put his furniture in, it was done. Because it was carpenting and changing floor, there was no tenancy. Act doesn't apply. We don't have jurisdiction.
You see? Okay, thank you. That was, you can see that the details like the dates and the little things that can happen or not happen can make it or break it. So that is about the cases where you have individuals. And by the way, before I move to corporations as tenants, I have to make sure you understand if there is one individual, put that name on the lease. If there's a couple, put both names on the list. Later, we need them when you come to us to file something with LTB. Even I would suggest if there is an adult person, if they have a son who is living with them and is adult, why not do that? Tomorrow we might have to go after all of them. Anyways, that is for individuals as tenants. I've had cases where there is a corporation. There are companies, there are businesses. They rent your place and then rent it out for short-term lodging, 1 week, 2 weeks, and they make good money. Then your tenant is the corporation. Then your due diligence calls for a, a corporate search. Do something to make sure what is the latest business name. Who are you dealing with? Now you're dealing with a legal entity. I had this problem a few months ago. You have to find out with that corporate search, at least you know who are the directors. And because the lease was not done properly, when I checked when I ran the corporate search, I found that the spelling of the name is a bit different with one hyphen. That was a smart thing to do. The name they put on the lease agreement didn't have that hyphen thing. And also the name on corporate profile was not the one we thought, she is rich, we could go after her. Then we found that she doesn't have her name on that corporation. So when it comes to and by the way, in that case, I suggested to the real estate agent, I said, you knew that this is going to be a business being run in at that property, why did you do it on residential lease agreement? Why didn't you, Ali? Would you suggest that?
No, if you even put in residential lease agreement, there is some cases, and say the landlord will charge HST, that's for commercial purpose, that agreement will be commercial. But I don't suggest even rent it to any corporation. Just put one of the director as an additional tenant. I mean, if they don't want to accept, say, okay, that's fine. Not just for 1 month, one commission. It doesn't worth it, I mean, that's so. The point is, even if you put even commercial purpose and if the police involved and you want to do the trespass, you have to go to the board. You have to establish it was commercial. You have to have an order of judicator say, oh, it's commercial. We don't have jurisdiction. Residential Tenancy Act doesn't apply. Then you can go bring a bailiff or somebody to put them out. And it will take 6 months. Now, 6 months, they live for free.
That's why I suggested that you do it as a commercial transaction, a commercial lease. And when you're doing the corporate search, then you have something you might have to add as AKA, also known as, because companies, they register names, business names, and then they go ahead with that business name, which is only a business name. They pay $60 to register a business name. Then you don't know who to deal with. So again, we are still in the beginning. There is a lot to cover. I have to go a bit faster. We haven't started with the paperwork yet. Now, imagine you have done all your homework, and now you're doing the paperwork. So two issues in the beginning. One is to make sure you have the right tenant. The second thing is you make sure you do the paperwork properly, and this is where we have to be more careful, because whatever you put on that lease agreement later, it can work for you or it can work against you. For example, uh, you have to make sure the rental cycle, very important. Is the payment being done beginning of every month? These things have to be very clear, because when we are doing the forms, even the dates on the forms become important. We lose a case only because the date on the form didn't exactly match the beginning of the cycle or the end of the cycle. So be careful with make sure, for example, if it is 15th of every month, that means rent is collected on the 15th of the month. The cycle ends on the 14th of next month. These things I mentioned because we have to deal with them on a daily basis, and they become very important when you're dealing with N4, when you're dealing with N12 and stuff like that. So that's something I wanted to draw your attention to. And next thing, I have seen that people make a mistake. I'm talking about the first and last. Ali, how many months are we allowed to
No,
collect in the beginning?
you can collect even 1 year, doesn't matter. But never put first and 4 last, 5 last, 6 last. Put 6 first, doesn't matter. If the tenant give a consent and it has a bad credit, the landlord can say, okay, if you don't pay me, I don't give you. I would say, okay, tenant say, okay, I will pay 6 months advance. Okay, you can say 5 months first and we keep 1 month last. The act said is not legal. You cannot negotiate any terms of payment, but there is a common law support that which you could get. But when you put last 4 months, for example, the tenant start in June. You take it June and say, okay, last 4 months, which will be next April, May, and March. Okay. Now the tenant pay June, don't pay July. You want to give a notice. What notice do you want to give? Say, okay, the tenant didn't pay us. You go to the board, say, okay, you had 3 months in advance with you. What are you talking about? You already collect your rent. What is the last? You know, that is a big problem. Big problem. Don't ask for, I don't know why this common in the real estate agencies. Every realtor does that. Maybe they thought something wrong in the RICO. I don't know how come they asked for the last 4 or 5 months. And I have so many real estate agent friends, and they say, yeah, that's correct. That's the law. No, that is not the law. That's wrong.
So
Other things,
we have only one last month, not 2, 3 last months. If you want to have more, a bigger deposit, don't call them last month.
and,
Sorry.
and you cannot ask for damage deposit. That's illegal. You could be prosecuted if you ask for damage deposit.
That was
The
going to be
only
my next
deposit,
question.
only deposit you are allowed is a key deposit, which could be reasonable, $200, $300 max. It is a fob key, max. You cannot ask for $500 key deposit. That's wrong deposit. I suggest maximum 300, even 200, because then they can go and what we say is based on the Residential and Tenancy Act and amendments which recently amended. You could be prosecuted if you violate the act. I mean, that's like a provincial court prosecution. Honestly, I've never done any hearings for prosecution, but it's part of the act. You could be fined by the law enforcement agency of the Landlord Tenant Board, Social Housing Enforcement Agency. They are like a prosecutor of they're the Landlord Tenant Board police, exactly, if you say.
Very good.
But be careful when you draft your lease. Yeah, if the tenant, Pat asks, if the tenant agreed to pay 4 or 5 months, if it is advance payment for rent only, the act say it's not allowed, but there's a case law support that. If you're in trouble, you can call me, I will support you. I mean, but never ask for the deposit for the last. You can ask for first. And if the tenant agree, make sure you put in your agreement, tenant consent and agree to pay in advance because they don't have a good financial situation. The landlord wants a more secure credit. Nothing wrong with that. Maybe it's another question by Bahman, but I will ask, I will tell.
Go ahead.
You're welcome, Pet. You cannot put no pet. That is, nothing is above the law. You cannot put no pet. There is a section of Act, Residential Tenancy Act, they say no pet section is voided. That's it. Yeah, you can have 2 years in advance. Nothing wrong with that.
Yeah, that again, I have to add, it should look like the tenant volunteered to pay you. It is not, it cannot be a condition put forth by you. You can't say, I won't allow you in, I won't sign it unless you pay 12 months, 6 months. But because sometimes when they come to landlord tenant board, they say, oh, he made me pay 6 months in advance. It shouldn't look like that. It has to be, you have to make sure it is volunteered or it is suggested by the tenant.
And
Back to,
the case I'm telling it's supporting that it was actually 1 year in advance, and that case go to before the divisional court. It was 1 year advance and one damage deposit. Okay. The court allow advance for rent, but the court even fined the landlord for damage deposit. You cannot ask for damage deposit. That's very clear. Okay. But you can ask for prepaid rent. The Act section, I think, is 82. Say you cannot ask for prepaid payment of rent or any negotiation, even direct deposit. You cannot ask, but if there's a voluntary consent, that's okay, but no damage
very
deposit.
good. So before we move ahead, back to that last month, I have seen people making mistakes, even agents. That last month is not for the 12th month of that year, unless it is going to be only for 1 year. If this tenant is not moving out and he keeps living there for the next 6 years, you don't allow them to use that last month rent is for the month at the end of which they move out. It could be 10 years from now. People call me and say, yeah, I've been here for 3 years, and I say, how much is the last? And they, yeah, we used the last 2 years ago on the 12th month of that year. Then that was, how come you're still living there? If you are living there, you cannot touch that last year. That's last year rent, last month, sorry. That last month year rent is for the last month you live there. And when we do the paperwork, they ask you to, if you have paid interest on that. So this last month rent is supposed to be with the landlord, because you have to pay, give him a 60-day notice with the last rent check that you're giving to them. When it is 60-day notice, that means after 30 days, he's going to use your last month check, already use it, of course. But anyways, so again, how about security deposit? We don't have such a thing, security deposit. These are the things that are used against you as landlords when we come to help you with the troublesome tenant. So that was it. Good. You keep stealing my thunder, but anyways, I was going to ask you about the pet. Some of the clauses that you put in the lease, they just don't work. One is pet. No pet, you can't refer to that when you take the tenant to LTV. You're not supposed to do that. But there are cases, if there's there are cases when it comes to, maybe after 5 minutes we get there, the reasons for which you want to evict the tenant, then one of them could be the pet, which is giving others hard time and stuff. But no pet doesn't mean much in our business. And then I see that you add a sentence or a clause in the lease agreement to deal with the snow or the lawn. That's part of the maintenance. And Ali, maintenance is what?
I mean, I suggest that if you want to draft a lease, you can say, for example, you agree with the tenant amount of $2,000 in total for lease agreement, and say, okay, tenant say, okay, I take care of lawn and snow. Say, okay, 2,000 you put. I suggest that you put your lease $2,200, take the last and first same fee, and put a clause and say, if the tenant maintain this property, this part, he or she will be compensated $200 per month for this. It shows that the tenant is working for you to take care of the property. If the tenant doesn't maintain, the rent is $2,200. If the tenant maintain, they pay $2,000, you're good. I mean, there is one things you can put in the lease, protect yourself against the tenant. Some clause you can put for lease, maybe you can put, for example, non-smoking. That's legal. You can say non-smoking. Even I suggest that you put the plant, cannabis, weeds, these things. Even you can add, okay, they are not allowed to put cannabis inside the property, because the tenants, they come and use the basement as they put a weed on the
Grow house.
basement. In this house, it is so much humidity, it damaged all walls, and the basement become molded, and it will be crazy. I mean, you can put those clause. There is nothing wrong with that. The clause which is by rules. But if you don't put it's non-smoking, if the tenant come and smoke, you cannot say why. You should put non-smoking. That's one thing inside the lease agreement. You should, and actually the new lease agreement by Ontario, it has all these clauses, and whatever you want to add is section. You can put as a schedule attached to the lease agreement. The clauses like lawn, taking care of the lawns, backyards, I don't know, snows, and be compensation. That's some different contract. And I have one bad news for all landlords. They increased the rent 2022, come yesterday, 1.2%. And the rent increase now, the legal from 2022 will be 1.2%, which they suspended for 2021, but yeah, I know that if you agree with the tenant, but be careful. And this is respond to one of the people ask. If you cannot negotiate anything on the lease which will be for future. For example, you cannot come and sign the lease agreement and say, okay, sign this N11. Okay, that N11 is void, even if it is for 1 year later. You cannot put on the list, we will increase 5%. That is what. But if the tenant pay with a period of 1 year and don't file any application, don't have any dispute, the new act, which is the Protecting Tenant Act, which was Bill 184, allow you to accept that increase was legal increase. But if you increase the rent, let's say, for example, you come and say, okay, can you, for example, Stephanie, can you pay $200 extra? She said, yes, I will pay. From next month, she start payment. Month 11, she file an application. They collect illegally $200 from me each month. Will be $2,000. And now I want my money back. You go to the board and say, yeah, they signed, this is the agreement. The board said, did you give a 90 days notice? No. Did you go by the guideline? No. That's the wrong increase. You should pay all back. Even they fine you, even you cannot collect your 1.2%. This 1.2% also you have to give an official notice, 90 days notice with the, I mean, I don't suggest if you cannot give actually, the landlord can give the official
Oh, yeah,
notice.
that was against some point. I was going to get there. I have to move a bit faster.
Yeah, go ahead.
Liability insurance, I just want to bring up the issues. Liability insurance, I highly recommend that you get the tenant to have their own liability insurance. They have, that's even more important than the property insurance for the stuff that they
Yeah,
have.
there is a question about when the tenant give notice of termination, the landlord can go see the residential complex at any time between 8 to 8 without a notice. That's by one of the clauses of the act allow the landlord going inside without a notice. Another thing is emergency situation. For example, if there's some, I don't know, fire, something, landlord can. These two things, landlord does not need to give a notice because they ask a question about that. Yeah, insurance is very important for sure. And even if the tenant does not provide the second insurance, I think you can give a proper notice to ask for termination of tenancy.
Yeah, okay. The day I also recommend that you protect your landlord client if you want to be there or at least tell them how to do this uh, before they move in. You document yourself. You go in with your maybe cell phone on, and you videotape everything, the outside, the inside, whatever you think is important when it comes to maintenance. I had a case, we complained for, they neglected the lawn and it was all totally gone. And it would cost the landlord several $1,000s to put back some fresh lawn. And then tenant simply said, it was like this when we came in. So you try to, before you give your $2 million worth of asset to somebody else to come in and use it, do whatever due diligence it takes
Uh,
to protect yourself.
I'm answering to Sia Mansouri. Uh, you cannot ask for last 4 months. End of the story. I mean, if you're not sure about the tenant going to pay rent, don't give a rent. That's it. Don't ask for last 4 or 5 months. That's illegal. Okay. As far as we know, I don't know. They said there is a law coming. I don't know any law for that. You know, if the current tenant doesn't allow you to showing, you have to give. If you give a notice for showing, if you give a proper notice, and the notice of entry should be posted on the door minimum 24 hours, and the time should be explained what time. If not, you can ask the law enforcement agency to charge them. I will give you the number of the law enforcement agency. What's going on? Something wrong.
You have
There is an echo going on.
Somebody's is on. It's not from my side. Okay. I will give you the law enforcement agency number. Let me see. Notice of entry for inspection. If the tenant doesn't allow, you have a picture of the notice you given, posted at the door. You have to post the picture at the door. You cannot email the notice unless the tenant consent. Then you can call this number 416-585. Let me just type it here for everybody. This is a social housing enforcement agency which protect landlords and tenants. And this one, they will prosecute. You can report, say, okay, we have a proof. We give a notice, they don't let us to show. Then you have to come and hire somebody to give a proper notice to terminate the tenancy because tenant doesn't cooperate, which
Thank you very much. And Alex has a good point here. He says, after 1 year lease, the lease automatically converts to month-to-month lease. Yeah,
yeah.
that's the point.
But the explanation of one to month always should be 60-day notice by the tenant to the landlord to terminate the tenancy. And the 60 days, the end date should be end of the terms, which Mr. Rudgarnia explained what is the terms. But if they both landlord and tenant consent and sign forms to terminate the tenancy, even from tomorrow, nobody say why you terminate your tenancy. But to add to one of the first thing Mr. Rudgarnia said, the terms, never ever put the same date for the starting and ending. I saw so many leases, they said start 1st June 2020 and 1st June 2021. Never put that. Or start 15 July and 15 July. Put 1st, 31st of May. Put 15, 14. Always put, because when go to the problems, when you go to the landlord tenant problems, maybe we have to give several notice. We go before one board member, that board member come and say, oh, the period is not like this, it should be like that. I will give you one example. One of my clients himself give a lease and say, okay, the lease start from 11 of the month from this year and 10 of the month on that year. But the tenant shall pay rent from 10 of each month. He gave a notice from 11 to 10. We go there, judicates say when the payment is 10, duration is 10 to 9, application dismissed. That's it.
Very good. So while you read those two comments, Ali, let me cover a few other things.
Okay.
Um, Representing landlord or tenant, there is something we have a case in which real estate agent has signed for the landlord to give N12 to the tenant. Remember, Ali, the now the real estate agent is on the hook, is on the hot seat because he tried to help without going to the landlord. He signed the N12, and then the deal didn't go through. Now both sides are going into a litigation because the tenant didn't move out,
Okay.
and the result is the agent, Ali, we were discussing that, the agent, only because he signed, and you are not a signing authority here.
Yeah, and landlord bring an action against the agent because say, why you sign on my behalf? Now they sue the landlord.
No, no, thank you very much. I really appreciate all your help, sir.
What happened?
Thank you,
think so.
sir. Thank you. Thank you.
Okay. For the clause, one of the one person asked that there is no clause on the new list for put for you can first and last. You cannot put for last. Yeah, you can put an amendment. You can put a schedule. The landlord collect 5 months in advance. Nothing wrong with that. Yeah, and as long as that transaction go through, it goes through. I mean, nothing wrong with that. You can put the normal list first and last, then put additional paper. Uh, and technically, when you go to the litigation, if they have a lease agreement, they will refer to the lease. But if you don't have a lease agreement also, they say, okay, what's the duration? What's how much they collect, how much they pay? I mean, it will be automatically they said, however, the landlord is obligated to give a written lease agreement based on Residential Tenancy Act. But so many landlords, they don't have any lease. They have just piece of paper. That's it, or just checks. So, you're muted. Okay.
The bottom line we're going to get before we run out of time will be to ask you real estate agents not to get involved with our job. I mean, there are certain things when you make a very small, very on nitty-gritty things which you might think doesn't count, and then you go ahead, or you get us to go ahead. We go in front of the landlord tenant board, and because of very small mistake, even a mistype, they're looking for something to get rid of your application to evict the tenant. So the bottom line is, as paralegals don't sell or rent homes, you try not to get involved with the legal side of it. Get one of us to help, even if you're doing the job for. One of the things I want to draw your attention is the right manner of serving. Sometimes we go ahead, and because that form was not served properly, for example, a notice, some notices you can leave in the mailbox. Some of them, each one of them, you have to know exactly how to deal with that notice. It is not that you choose how to pass it to the tenant if there is a notice. Ali, could you give us some
I will
insight?
give, but I have to answer some question. First of all, to Ray Neely, I don't know what is 2229E. Maybe you can explain. For Nancy, you don't need to give any reason to potential tenant you don't like them. As long as you don't sign a lease, as long as you did not enter to the tenancy, nothing wrong with that. You can choose 100 people and say, I don't want to give you. Nobody say why. If they come even after the board and say they didn't give us, maybe some, I had some, okay, they say it's a human rights. They go to human rights court also, they lose. Doesn't matter because there is nothing. But about the lease, you know that I saw so many people, not real estate, everybody. They come up, oh, we wait 6 months, we go, they dismiss our case based on technicality. Of course, they will dismiss the case based on technicality. When we deal with the landlord tenant board, the main thing is the notice given to the tenant to be proper and correct service. If the service is wrong, if it is not proper served, the application will be dismissed by somebody like me within 1 minute, because the rule is very clear. Within last 2 months, I can say how many applications I dismiss when I represent tenants, because I have to represent my client. Maybe it was unfair. Yeah, of course, it was unfair. I don't like it. It was $30,000, rent areas, but the landlord had mistake. They didn't go to some licensee, and I don't suggest to go to the lawyers for that. Lawyers, they don't know how to deal with these matters. If you go to some lawyers, find a lawyer which they're few, they just deal with the landlord and tenant board application. There are few lawyers they do that, because you lawyers there, it's like a small football or soccer play, or the big soccer play. We cannot go to the big soccer play, but we know how to, play in the small as a small soccer player. And the same thing is for the big soccer player. Don't never issue any notice on behalf of your client against somebody like me and come and dismiss your application based on the Court of Appeal decision. I have done that several times. For the property management companies, I suggest that if you put the property management name on the notice, you put the landlord name also on the notice, and get the landlord sign, or give some legal advisor like us sign. Because then when you go to the board, because the interpretation of the act is covenant interpretation by land, sometimes they say owner is the landlord, and you could argue and dismiss the application. For the new, the lease, I go further because this something come to my mind, Bahman. But for the leases, like the leases, you sell the property with a tenant, okay? The new landlord is responsible for everything. If there was any dispute between the previous landlord and the tenant, again, the new landlord is on a hook, not the previous landlord. And I have already dismissed so many applications based on the previous landlord was not responsible,
This last thing Ali brought up about N12, you want the unit either for your own use, your son is moving in, the one that I'm dealing with this week, or the last month we had this landlord, she was a lawyer herself, and she wanted this for her father-in-law, and two applications within 1 month she brought, and we uh, kicked them out of the window within 2 minutes, only on technicalities. And she was just in front of her camera with a mouth wide open. She said, only because the date is wrong, you're dismissing. And the board member said, yes, the
And landlord
application
was
is
a lawyer,
defective.
actually.
And the landlord was a lawyer
Herself.
herself. She was a landlord, and she thought, so we are running out of time.
If they add, I answer some questions. No, the tenant can bring a discrimination. Everybody can bring any application, but if whether they are successful or not, that's different story. For the, if they add father, mother, sister, as long as they can bring a roommate. I mean, the tenant can rent a property and bring a roommate. There is nothing wrong with that, as long as they follow up the health guidelines and the area they stay in is based on the guideline of the Ministry of Health, you cannot evict them. However, if there's overcrowding, there is some way to go for overcrowding. But father, mother, sister, if there are 10 people living in a 2,000 square feet house, there is no overcrowding.
That was going to be my my final points. Ladies and gentlemen, it is not an easy job to evict a tenant in this province. So other than non-payment, if the tenant is not paying rent, and we all know that it takes us 6, 7, 8 months to book the hearing, then the tenant is living free as a guest for the landlord for several months, like these cases that we are dealing. We had it last week, this week, and also next week. I booked this. In October, and I'm dealing with it in June. Imagine 9 months. Other than non-payment, there are only a few cases, and there are applications for those cases that you can apply to evict the tenants. Just like the one you said, overcrowding. What else do we have other than overcrowding? Again, overcrowding has its own definition. You have to be careful how you draft the application. What else? Illegal things.
To answer one of the questions, if there is a kind of problem with the smoking of weed or smoking of anything, if you didn't mention in your lease agreement, you should get a legal advice to what kind of notice give and how you can terminate the tenancy, because it's not that simple. I can say because every case is different. I say we are not giving legal advice, but every case is different. Should be reviewed. What notice condo given to the landlord? What was the problems? Then see whether if we can give a proper notice under the Residential Tenancy Act, whether that notice is voidable, non-voidable, because some notice they will be voided, some notice won't be voided. And, it depends on the circumstances. It's not something that actually somebody has to take a look. Somebody, and be very careful. Some paralegals, unfortunately, right now, because it was they were doing the traffic tickets, and now the COVID come, traffic ticket courts, they're closed. They come to the landlord and tenant boards. They don't have any clue. They don't have experience how to issue the notice. They're like, same as in, I go to the personal injury courts. I never do that. Or WSIB. I don't know how to deal with that court. I never touch that court. They come to the landlord tenant board, they give a notice, they sign a notice, but notice is defective because they don't know how to calculate. You try to speak to some people, they do actually landlord and tenant board. That's very important. There's so many out doing landlord tenant applications. They are very respectable colleagues. They do that, but some other colleagues, when they do other course, they don't know landlord tenant.
I believe we already ran out of time. So let me thank on my own behalf, on Ali's behalf, from your brokerage, and from Mr. Javdan, from Alex, and everybody who was moderating this session. Hopefully, in the near future, we will come back to share with you some more thoughts and points so that you can help with the tenancy issues more efficiently.
I appreciate also this time an opportunity you gave us. Honestly, I'm doing this landlord tenant applications. I'm telling you, since the starting of my practice, 6 years, I'm doing that. Still, I have some doubts about some notices and some application. I get advice from my different paralegal friends who they doing the same. And even the adjudicators sometimes they don't know what to do. We have to convince the adjudicator that's how it goes, you know, because it's a very, when I go to the landlord tenant board, I apologize my French. I say, welcome to the zoo. It's like a zoo. When you go there, you have to be careful what's going on over there. You know, it's very, very tricky. And I hope you never have any problems with the landlord tenant issues as a real estate agent, but this is something uh, happen to everybody, unfortunately, especially recently. It's so much. I mean, I cannot do other practice because it's lots of application, you know, and now coming to the hearings. And
Thank you very much.
yeah,
I have one question for both Ali Reza and Bahman. Can you guys just tell us a little bit about how do you charge if we need to hire you?
I charge flat fees, different fees, but technically paralegals fees is around 100 to $200. It depends on the area of practice, but normal hearing will gonna cost around $700 plus HST if we just want to do the hearings, because and there is no guarantee you can do that hearing. But if you want to tell the landlord, you can say how much is the rent you're going to spend around 1 month's rent for the, you know, it's gonna cost 1 month's rent if it is, and rent usually is between $2,000 to $3,000. You know.
Filling out just the final point, filling out the proper application and filing with LTB is going to cost maybe 550, something like that, right? More or
It
less.
depends on the notice. If it is just non-payment of rent, yes. But if it is a
Sometimes you have to
personal
write
use,
it up.
yes. But if it is a some comments was they have a smoking problem in condo, it won't be $500. Maybe God cost you for just notice around $500 application, 500 on top 1,000. It depends what kind of problem you have. You know,
Thank you so much,
no problem.
Mr. Rugarnia. Thank you so much, Mr. Hesami. Thank you, everybody.
You're
Thank you,
welcome.
Alex.
Thank you,
I hope-
doctor.
Thank
Have a
you.
great weekend.
Okay, you
Hopefully,
too.
we can see you again.
Hopefully.
That was great presentation.
Yeah,
Thank you, everybody. Have a
Looking
wonderful
forward to it.
Okay, have a good day.
Thank you.
Thank you,
Bye.
everybody. Thank you, everybody. Thank you so much.
Thank you.
Jerry.